I might have to take this clip down after we play it. It might not be something I can actually have on this live stream, but we'll watch it anyway.
The Idaho student murders. The suspect is due in court this morning. As we hear from the family of Kaylee Goncalves, they're sharing never before released images of their daughter, and our Kana Whitworth sat down with them and joined us from Moscow, Idaho. Good morning, Kana.
Michael, good morning. An incredibly emotional conversation. Kaylee's mom says she feels like they've been in limbo now for more than a year. And while she's hopeful as they get ready for these two pivotal hearings here today, mostly what they want is a trial date to be set.
We're just left in limbo.
This morning, Kaylee Goncalves' parents sharing exclusively with GMA never before seen pictures and videos of their 21-year-old daughter.
This is a type of, you can like season with these. Actually, you can't really season with them, but you can cook with them.
Yeah, I know that's in front of the tower.
Yeah.
This is in front of the University of Idaho Tower.
The family still waiting on a full digital copy of Kaylee's phone from authorities.
These are the last moments of your child's life, and you're sitting here fighting with somebody who just doesn't care.
They were able to collect some of Kaylee's belongings from the university over the summer, which raised concerns for them about how well possible evidence was processed, including a trash can from Kaylee's room that was full and appeared untouched.
We opened it. It was a little squeezy applesauce thing like you would give to like a toddler. It did not appear to have been gone through.
Police saying they had gathered more than 100 pieces of physical evidence from the scene, along with some 4,000 photos and 3D scans of the residence. Still, frustration mounting for the family over what they consider a lack of communication and a rush to tear down the home on King Road. Christy describes for the first time how Kaylee was found.
It's my understanding Kaylee was kind of sitting up.
Yes.
And had fought.
Yeah. And the way that room's put together, if you come through that door, you can't get out of that room.
Completely, totally trapped.
Yeah. You're in a bed.
Tiny room. The bed was the entire room. You could barely open up the door without swiping the foot of the bed. And it was wall. You know, the headboard was up against the wall. The side where Kaylee was on was up against the wall. And if you can imagine Kaylee in an upright sort of position up in the corner, slumped. I mean, she was trapped.
The home on King Road was torn down in the pre-dawn hours of December 28th.
Now, the first of the two hearings today is closed to the public. The judge is also holding a scheduling conference later this afternoon. Remember, the prosecution is asking for a trial date to be set sometime this summer. Guys.
Okay, Kana, thanks very much.
The suspect in the murders of 4 University of Idaho students due in court today. It comes as we hear from the family of Kaylee Goncalves, one of the students killed in 2022. Her family sat down with ABC.
I have really not much luck with ABC News, but they might let me play this. Well, I just found a good video for us. So before we'll keep that as a backup to watch, but I just found a video that was just released 59 minutes ago on Long Crime. And this is about the full screen again. Sorry, guys. And right here.
More updates and hearings in the case of Bryan Kohberger means more back and forth with criminal defense attorney Andrea Burkhart. We get into the defense asking the judge to reconsider their arguments to dismiss the case. Kohberger's team now having access to DNA records and whether any shady stuff happened with the grand jury. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. So we had such a great response to our first Bryan Kohberger debate, back and forth, whatever you want to call it. It's an episode we did, and we figured, why not have another one? And I'm not sure where it's going to go, but it's going to be interesting. I mean, so much to talk about in the Bryan Kohberger case, the Washington State University grad student accused of murdering 4 University of Idaho students back in November of 2022. Authorities say Madison Mogan, Xana Kernodle, Ethan Chapin, Kaylee Goncalves, they were all found stabbed to death in an off-campus rental home. Bryan Kohberger, a then 28-year-old PhD criminology grad student, was arrested, indicted on murder and burglary charges. He faces the death penalty. And prosecutors have tied him to the crime through cell phone data, DNA on a knife sheath left at the scene, a potential eyewitness, surveillance footage of a white Hyundai Elantra that investigators say was at or near the house on King Road the night of the killings and on previous occasions. But now there are some new developments, and I want to debate it out, maybe, with Andrea Burkhart, criminal defense attorney. You can check out her YouTube page at Burkhart Law. You can also go to her Twitter, X profile. It's the same handle. Andrea, thanks so much for coming on. Great to see you.
Thanks, Jesse. It's great to be back.
Great to have you. So let's start with the hearings that are going to happen this Friday. So let's break it down. So the defense is trying once again to get the case thrown out. They have argued that the grand jury indictment cannot stand because evidence was withheld from the jurors, that there was a question of jurors' impartiality, that there was insufficient evidence to support the charges against Bryan Kohberger. Judge John Judge previously rejected all of these arguments. He wrote in a filing, quote, that the defense attorneys had failed to successfully challenge the indictment on grounds of juror bias, lack of sufficient admissible evidence, or prosecutorial misconduct. Kohberger, quote, was indicted by an impartial grand jury who had sufficient admissible evidence to find probable cause to believe Kohberger committed the crimes alleged by the state. And he wrote further, the state did not engage in prosecutorial misconduct in presenting their case to the jury. So first, let me give a caveat to everybody. We don't have a lot of information. This is under seal. Let's keep that clear. Having said that, Andrea, any reason why the judge would rule differently on this now?
Well, there's generally two reasons why lawyers will pursue a motion for reconsideration, because speaking very frankly, judges don't typically change their mind. If they've read the pleadings, they've heard the argument, they're familiar with the issue, and they had a reason for the decision that they made. So the reason for bringing a motion to reconsider first can be because there's a specific issue that the defense thinks is important that the judge either did not address in the ruling, or they want him to flesh out his reasoning for it. And the reason why they would want to do that gets to the second reason why you file a motion to reconsider, which is that you're positioning the case to ask for an appeal. So typically, appeals, you have to wait until the case is completely done and resolved before you're allowed to go to a higher court and ask them to find that a wrong decision was made. But there can be exceptions for that to be done while the case is still ongoing. Idaho has a specific rule for how this is done, and it appears to me that this is a big part of what the defense strategy is in bringing these motions in the first place. They're required to bring this motion to the court, ask for permission to appeal. So they would be potentially asking him to flesh out reasons for his decisions so that they can then present that to the Supreme Court as essentially the question they are asking the Supreme Court to rule on, whether that decision was correctly made, whether the reasoning was correct, or whether it was not.
And also, to be clear, this hearing we're not going to see. It's sealed. It's closed to the public because of the privacy of the grand jurors and the grand jury proceedings. Look, I'm of the opinion I don't see much success here for the defense. I mean, you really laid it out well. I think it's a pretty high bar. It's not like there's been a change in the law. Maybe they have new circumstances, new evidence, maybe to say that to prevent an injustice. I think I agree with you. It seems more that they're trying to create a record here in order to appeal. I think we agree on this one, so maybe I'll move forward with this one. Let's move on. Let's move on this one. Okay, so this is the one that I thought was really interesting, and I really wanted your opinion on this because I can't quite get it. I want your opinion on the defense's argument to unseal their motion for the judge to reconsider, denying their motions to dismiss. I know that was complicated. Let me try to say that a little bit differently. They want the public. They want everyone to know what happened with the grand jury. They want their arguments. They want more their motion for the judge to reconsider. They want the public to know this. They say, quote, Mr. Kohberger acknowledges the right of the public to be fully informed of the issues. The defense wrote in a filing. My argument is, and this is the way, it seems to me that, the grand jury is a private process. I don't see how they justify the public as much as we would want to see it. I don't see how they can win this argument. I don't see a justification for the public release of this information. It seems to me like they want to affect a potential jury pool, not taint, but affect a potential jury pool, because they're fighting this not only in the court of law, but the court of public opinion. So much has been said about Bryan Kohberger. That's not allowed, though. I mean, what justification could they have to unseal this for everybody to see?
Well, I first off agree with you on this one as well. I don't think they're likely to win this one. For all the reasons you said, the grand jury process is highly protected. But the defense has been signaling for quite some time that they want the public to know what the evidence is in this case. They wanted a public preliminary hearing. The state obviously is not required to do that. They chose to go with the secret grand jury process. So what they have against Bryan Kohberger is still extremely opaque at this point in time, beyond what was there in the probable cause affidavit. But even in the original hearing on these motions, Mr. Logsden had made a comment to the effect that some number of the grand jurors had expressed concern that this is all there was to the state's case. They had wanted to see more. He was kind of rapidly cut off from going further down that line by Judge. But it seems pretty clear that the defense thinks this is a thin case, and they want the public to be aware of that, in part because there's a need to balance the coverage that has been out there on this case. There is a lot of just presentation that tends to presuppose guilt, that has relied on a lot of information floating around that isn't necessarily accurate. We've seen a lot of inaccurate information being put out about this case for quite some time. So I think the defense does want to respond to some extent to that media environment. But as you said, this is a protected process. So the only way I could really see this being viable is if the defense was so careful in how they crafted their motion that they didn't discuss kind of the facts, the underlying actions that took place in the grand jury, and simply kept it at the 10,000-foot abstract legal issues, where it wouldn't be necessarily revealing anything the grand jury did, but just kind of talking about, the principles of the issue. I still don't think that would get them there, because, if you're talking about principles of process.
Okay, Judge just went live, you guys. So let's switch to his channel. Here we go. Good thing I set that alert. Here we go. Oh wait. Oh my gosh, I have so many open. All right, well we'll just backtrack. We're on YouTube here. And just gonna go to my channel and then go to my subscriptions here. Judge Sean Judge, here we go.
Mr. Kohberger obviously is in his courtroom. The state is represented by Mr. Thompson, Ms. Jennings, who is here also remotely, Mr. Nye, and Ms. Beatty. So we're here. This is an open case. You probably know we had a closed hearing this morning, and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you've all seen the amended order governing courthouse and courtroom conduct. We made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can go to the Supreme Court website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the a claim of inaccurate instructions to grand jury. Also, coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
We can, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Logsdon? Reply.
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank
you. Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it refile it, as Mr. Nye said. So that's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
You want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential fulfillment. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, is just simply appealing to raw emotion, and it has no place in this courtroom. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Taylor.
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, council and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and council in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and council recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and council to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards, in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator, and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Miss Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have 1 of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just 1. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub files. And I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case. And I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So sure. I understand this. I mean, I'm aware of amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. if you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you
that. This is priority for everybody. And I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, and there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And I don't think that's going to change anything, Judge. When this case has national, if not international, attention. This spring I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow, it's not Latah County, it's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first, and not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention Kohberger and said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Lake Charles County.
Okay. Thank you, Mr. Thompson. So you're saying, you're looking at this realistically and the amount of information, evidence, non-evidence, that might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe in March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. There's going to be a lot of motions about the death penalty as well.
Yep.
So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal. And that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain. The grief.
Thank you, love. How was it?
Because you can't really go forward if your life is hanging over your head. So, I'm sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. So, does that conclude what we need to talk about today, Mr. Thompson?
believe so, Judge.
Okay, Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
Okay, it looks like his stream is just stopping. Let me pull you up full screen, Gia.
Okay. Hi.
That was hey, welcome.
Thanks. Yeah, I'm sorry. I'm like discombobulated. I didn't know I thought I was still backstage, so I was talking to my son. And thank you for muting me.
No problem. Sorry about that. That was my
I
bad.
don't know.
You know, it's weird. I feel like everything got adjourned without an actual court date. Did you what happened just then?
So what happened was they're both kind of vying for a summer of 2025 date, and the judge is very uncomfortable. He feels like this is going on too long, and he doesn't even feel comfortable with saying March of 2025. But I think what he said was, since this isn't even going to be happening anyways for 2 or 3 months, that he has time to let it percolate and think about it. And so he didn't make a ruling from the bench today.
So how long do you think it'll be when we hear back from the judge?
I don't think it'll be too long. I total guess, but I would say within a week he'll come out and say what he needs to do is set up a scheduling hearing. And the scheduling hearing ends up being like where you go for all the dates that are going to be coming up. So all the various pre-trial hearings and conferences and whatnot. And then ultimately a merits or a not a merits, but the trial itself. And that'll all be lined out in a scheduling order. So he's just saying he's going to wait. I think it's going to be March of 2025, and I think he's going to feel like he did what was right, because it's going to be appealed no matter what. If he gets convicted, just like he said, it's going to be appealed and appealed and appealed, and especially because it's a death case. So there's going to be more than one trial. There's never just one trial in a murder case like this. And they're setting it up for appeal in so many different ways. I mean, that's a given, right? So I think he's going to say, look, it's already been a year, and now you're asking for it to go another year and then another 6 months. So 2.5 years out. I get he waived his right to a speedy trial, but this is ridiculous. And yes, there's a lot of discovery, and there's a lot of tips, and there's a lot of this and that. However, they've had a year for, as it's coming in, they should be looking at the discovery. And, so if there's anything that new is coming in, okay, it's a lot, but this isn't the only murder case out there. Most don't take 2.5 years to go to trial. So why is this different? You know what I mean? By the time 2.5 years come, what are these witnesses' accounts going to be? They're not going to be fresh. Right. So there's that too, like all the eyewitness testimony. And I think Ann Taylor said there's like 400 witnesses so far. Did I mishear that? Because that's what I heard when I first jumped on.
Well, there's no question. I'll be going back to read that. I'll write that down in my notes.
Well, yeah, I need to watch it because, I hopped on so late. But very interesting. I was a little surprised the prosecution also is looking at a date that's maybe summer of 2025. It's just odd to me, right? And
it seemed like he was doing his best to argue against it, but it was like one of those things where somebody's arguing, but they know they're arguing for no point. They're just bringing up the argument.
Yeah,
he was going to get it.
And there's also the chatter about a new venue.
I heard that for the first time.
Yeah, that's my first thing, which is not shocking. I'm surprised we haven't heard that before now, because I would, if I was Bryan Kohberger, I'd want to change a venue. That county hates him. I believe they've already got him convicted, so it's probably not fair to hold the trial there. And it almost seemed like Judge was saying he's expecting that, and then but but almost like this case has been so sensationalized and spoken about and, reported on that you'd be hard pressed to find a anywhere that it's going to seem fair because everybody's heard about it. I mean, the only thing is, even if we've heard about it and other places have heard about it, I think there's less maybe hate towards him. I don't know, for lack of a better word, but I just think it's really raw right there in that county. So just even moving it maybe to another county could be helpful. But if they don't do a change in venue, then that's going to be maybe a reason to appeal. She set it up today to say, if you don't give us the date we're looking at, like the earliest summer of 2025, then I'm going to say that he didn't have effective counsel because I wasn't able to do my due diligence. I mean, those are some of the things that she's setting it up for appeal already. So
Now, I've heard something in the past, and I don't know if it goes state by state, but in certain murder trials, there's a mandatory appeal trial. Am I incorrect that I've heard that before? Or
you might have heard that, but it is definitely state. Every state is different with their rules and procedures for court and all of that. And, for instance, like Idaho is one of the only states that has, was that thing we were talking about the other day? The right to stand silent.
Oh, right.
Yeah. So that's like very unique to Idaho.
I thought you were going to talk about the interlocutory things, because I haven't heard that before until I followed this case about how that process works. There was a comment by Strange Suspicion, and you weren't in the room when they were ruling on this, but the first argument was whether to bring this to the Supreme Court or not. And is the Supreme Court, like, would they ever be a venue that this could be transferred to if they couldn't find like an unbiased jury pool? I don't know how this works. I just want to pose the question. Sorry to.
I have to look into that because usually you go to the trial courts first, and then you go to the Court of Appeals, and then there's a Supreme Court. So every state has 3 levels of that kind of jurisdiction, right? So it wouldn't go directly to a Supreme Court. Usually it would have to be a question of constitution, like a legal question relating to the Constitution, that you would go to the Supreme Court for something. So I don't know, but let's look into that.
Okay. And I'm just looking in here to see if we had any other comments. So I just want to summarize kind of, hey, Nene, I don't want to say any names out loud, but tell my little nephew I said hello, please.
Oh, Nico. That's okay. Nico, Aunt Kiki said hello.
Hello.
I don't know, buddy.
So I just want to kind of paraphrase what you were saying in the beginning. So if we want to paint a picture of what we should be expecting, possibly within a week, we might see something posted on the court website suggesting when they're going to have a hearing to find out the scheduling for the trial. Is that what we're looking at next?
Right. So what's going to come out is there'll be orders that come out that show that he rejected both of the right. I just came on really late, so I'm guessing he dismissed both motions.
Yeah, that's what it sounded like, but he didn't come right out and say motion dismissed. We just heard his arguments, and he said, "I don't think."
He said, "I'm not going to grant that."
Yeah,
I heard him say, "I'm not going." So what we can expect now is an order will come out, ruling on those motions. So they had the hearing, and now an official order has to come out showing like granted or not granted or denied, right? So that'll come out, and then he'll come out with a scheduling order, I believe, and that'll have the date of the trial in it.
So they don't have to have a hearing to find out the date of the trial. That's just something the judge is going to take all.
That's what they did today. That's what he did today. Yeah. So he was taught after the 2 motions were ruled on and they were all done. Then he went right into like, okay, now we need to talk about a date for the trial and the scheduling order. And the scheduling order will include when that date is going to be. It also include like when discovery deadlines are due. So that was one of the things he was saying too. Would it help you out if I tightened up the discovery deadlines, right? So a discovery deadline is, when does all of the information need to be shared? And that's it, like discover. Of course, it's always ongoing all the way up to the trial if something new comes up, right? But he was saying, like, if I tighten up those deadlines, making it shorter, right, to say all discovery needs to be completed by such and such a date. If I make that like 2 months from now instead of 6 months from now, will that help you get through everything and be prepared for a trial in March? Let's say that's what he was getting at. And I don't know. I don't think that they said it would help.
Okay, so okay, then that I think, because Pia had another question right here, which is, didn't he say in the hearing that he was going to wait a few months because in a few months it'll be almost summer?
That might be, I would have to listen again, but what I heard was, I don't need to say today when the trial is going to be, because I have 2 or 3 months, like, to percolate and think about it. It's not something that's going to be in 2 or 3 months. So it's not, time isn't of the essence for me to say it today. I think that's what he was saying.
Well said. No, I think that's a really good way to paraphrase what he was trying to say.
I
And of course,
think.
we'll get specifics on everything when we go back and review all this footage, because in the moment, there are always little things that you miss when people are talking. So
Right. And then they were saying there are going to be a lot of 12B1 motions coming up. And I think those are like motions that are similar to like a motion for summary judgment, where they're trying to say like they failed to, I don't know, provide relief for the client or state a case on which relief can be granted, something like that. Anyways, so I wrote down quick because I want to like look into that, and then we can talk about that maybe on another stream or something.
yeah, a quick question about the venue too, if you might know the answer to this. So if they were going to consider changing the venue, would it have just been decided now, or is that something the judge will bring up when he talks about a hearing date, a court trial?
Someone has to motion for it. So typically would be the defense would motion for a change of venue, and then the judge would have to rule on it. Because that would, you have to think about it. Then that would mean that it's not before judge.
Oh, good point. Right.
And I don't know if, maybe you know, but I don't know if they've already slated judge to be the judge that presides over the trial, or if he's just hearing all of the pretrial motions and ruling on that.
That's fascinating. I've never even thought about that question. I just assumed he was the trial judge. We'll find that out.
And he might be, but if they change a venue, he won't be. I wouldn't think, unless they can transfer a judge to the other venue. I don't know how that works, but I mean, that's all interesting kind of procedural stuff.
Yeah, it'll be really fascinating to hear when the lawyers get a hold of everything, what little tidbits they pull out for us to report back to you guys. So, can you think of anything that we went over a lot of things before court? Is there anything you think I should show the folks here, or any other insights that you think we can give the our viewers? We've got about 30 people watching right now.
I don't know. I just wish I had, I wasn't committed to something else, and I could have watched the whole thing. But
oh, we're just glad you're here. Everything you've said is I'm actually doing a little search just to see if I want to see if Lawyer did come out, or Court TV came out with anything, any rebuttals yet. Yeah, it doesn't look like it, but I'm sure we're going to have a lot coming out in the coming days, and I'm just grateful that we could get this live coverage to you. I'm sorry.
I just want to say, CB said, did the families have a say in the change of venue? I don't know that they have a say necessarily. However, they certainly would, be able to voice that to the prosecution, what they feel. And then, the defense is going to motion for a change of venue if they decide they would like one. I don't know if the prosecution would try to, say that they don't want that. I don't know. But if the families were saying to the prosecution, like, no, we don't, we want it to be here, we want it to be here, then I would assume the prosecution would try to fight to keep it in the current venue.
I'm just going to read Regina's comment. I know this means nothing at the beginning of the stream. Oh, very nice.
Yeah.
Yeah, that was
not usually dressed up. I don't know. This is just my I was just going about my day.
You look great, by the way. Did you get your hair done or did Nico?
Nico.
Oh, okay. It looks like you had your hair blown
I
out.
had to take him for a haircut at the worst time, right? Like,
on a Friday.
Yeah, I had to get him at school and then shoot him over to the haircut place. And of course, they were late, like a half hour late, and I was going,
That's like having a fresh haircut for the weekend for a teenager.
Yeah. Mm-hmm. That was Mom's doing, right? He would not have his haircut if
right.
If he had anything to say about it. Boise's pretty far, probably, but they say things as if this is the only case out there and deserves special treatment. I guess that's kind of was bugging me, like the way they were like, we have to have the proper lodging and we need to have this and that and we need to be able to investigate every little thing. You know what? You don't always get the luxury of all of the time in the world for these things. Right? You look at other cases. I would be curious. I always compare it to OJ just because it's such a similar case in the sense of sensationalism, right? That, back when OJ, it was all over the news constantly. We didn't have like all this stuff at the time. But,
I'm sorry.
No, I just would be curious to see from the day of the murder to the trial, how long that was. I guarantee it wasn't 2.5 years.
That's an interesting stat we'll have to go back and look at.
Mm-hmm.
Do you recall it was brought up in another live stream? How long was the OJ trial again?
I think it was 9 months.
Okay, because it was interesting. And I'm just replaying what we just heard in my head. And there was something that came out of this, which is Ann Taylor's impression of how long she thinks the trial would take. And she said a minimum of 8 weeks. I think she kind of doubled what the prosecution was initially saying they were saying for trial. I think she said 8 to 12 weeks, maybe.
Yeah, because I heard 6 weeks, but this is going to be a lot longer than that. There's way too much for them to present, and they're going to present it. I mean, you know what I mean? Like, they're not going to cut it short if there's still something left on the table. Like, once the cases are both presented and they both rest, I think you're looking at least 3 months. Mm-hmm.
I couldn't see it being less than that, especially when she sits there talking about there's so much data information with the 57 terabytes. She hasn't even had the chance to go through it herself. How are we going to present that in a 6-week trial? So
look how long it takes them just to get this crazy stuff. Like, you really think, and then they're going to go through every little thing. Trust me, I think, nothing moves quickly in a courtroom. There's constant recesses and, they start late and they end early. You probably get like a good 3-4 hours out of every day that's actually spent doing things that are productive.
The rest of it's all red tape or whatever.
It just, yeah. Right. Yeah. Red tape.
Process, I should say.
Yeah. It's just everything is, it's just tediously slow. I don't care what kind of court, divorce court, criminal court, civil court, it's all really slow.
Well, yeah. It's fascinating. I'm really glad we made it past this milestone. I mean, even though not much was said, I feel like I've taken a breath that we've gotten by this. There was so much, built up to this hearing today, and to see the defendant and to see Ann Taylor in action and to see the prosecution in action, it's interesting. It's just all interesting to see it's a snapshot of what we're about to be seeing coming up. Hold on. Yeah, just saying that how long it's going to take.
Yeah, but my point is, it takes that long for everybody. This is not unique. I don't think that he should get any kind of special treatment. And if this is all in the effort to not have an appeal, you're gonna have an appeal anyway.
Right.
You know, you don't get to say, you know what, I think it is gonna take me 10 years to get through all of this data. So let's have a trial in 2020, you know, or 35. No, you don't get to do that.
Yeah.
So I don't like that they're trying to push it all the way out, but what they're saying is, if he's innocent, then it's not really fair if you don't allow us to look through all of the information, and because there could be something in here that would make him innocent, you know, prove his innocence. And you didn't give me the chance to do that. And I needed 6 more years. Like, no, you don't get that kind of time. And I think Judge is leaning towards say, I don't think it's going to be summer of 2025. I think he's like, he doesn't even want to push it to 2025. Like, I think he'd like to have it at the end of this year. Or
I see where he's coming from, though. It's like you said, it's going to be appealed no matter what. But when these arguments come up, if it doesn't look like he's compromising in some way between the two parties, that right there, I don't know if it's automatic ground for appeal, but it's a great argument in court. Whereas, well, this was argued ahead of time, that nobody was having enough time to prepare for this. And so if he doesn't entertain that, it's just more,
right.
It's more chance for if somebody's accused, for them to be able to.
So I just wanted to, oh gosh, CB was saying OJ's wife was killed on June 12th, 1994. The trial started January 24th, 1995, 6 months later.
Wow.
So 2.5 years is ridiculous. And you know what? I get their point in a way, is like, so when it was OJ, really there was just the evidence that law enforcement had collected and whatnot to go through. They didn't have all these terabytes of information, because I remember at the time it was like AOL dial-up modem. There wasn't like this crazy, you know, internet that had all of this information and all these people reporting and all of this digital information. I don't even think they were smart. There weren't smartphones then or anything. So they have a lot more due to this digital age and technology than to sort through. But still, oh well.
Enough
To my point is, you've had a year to look at stuff. You've been getting this information for a year. So all that information should be going through.
Steve Holland, the reason this is dragging out is because the prosecution slow walked the discovery. Facts.
Maybe.
That's what Ann Taylor says.
She did, but then she did say today, maybe it wasn't really them doing that. She didn't think they were doing it on purpose. She was saying that I think they kind of agreed that all of the different information they were getting from the various agencies, and you really can't control that. So there really was no control of, like, when did the prosecution get it and how long did they have it before they turned it over, and that. So I think they kind of both agree that the discovery is coming in piecemeal.
That's good to hear, with all the doubt that's spread around, you know, here online. Just hearing that Ann Taylor at least can agree that one of the reasons is just the way that it's presented, and it's not necessarily the prosecution withholding something, which is the way it always feels like when you hear these motions for discovery and whatnot.
Yeah. Mm-hmm. Thank you, CB, by the way, for giving us that fact.
Yeah, thank you, CB.
Yeah, I knew it wasn't, you know. But see, then that trial went on for so long, so.
Yeah, how long? That's
I think it was 9 months. CB, do you know?
Yeah,
I feel
CB.
like we looked that up before. I feel like it was 9 months that the trial went on. So like 12 weeks, 3 months. And you're talking, they have to go through evidence for 4 murders, not just one. So this is going to be long. It's going to be really long.
Yeah, and I'm just looking to see. I was looking to see if any of my other, who's live right now and who's talking about it. if you guys want, we could check
I'm
out.
sorry.
Hold on. We got more stuff here.
Yeah, I saw it. The lady on the right is Gia.
And I am Kiki. And
Yeah,
this
but I
is,
don't know that I didn't pay attention. I'm offering an opinion based on what I heard.
what?
And
Oh gosh, I didn't even read the whole thing. That's
whatever.
well, yeah, and I will say,
That's
Gia,
why
I
I'm here.
think
I'm
you've
here
done
to
a
offer.
really good job breaking down the analysis. So
Thanks.
I disagree with SH. I think Gia's done a really
Thanks.
good job breaking down this for us.
Yeah. Yeah. 9 months. Thanks, CB. That's what I thought, but I didn't know. That was just in my head, but it could have not been correct. So yeah, 9 months.
Okay. Well, Gia, I think I'm going to go make supper now. I'm sure you probably do. I really want to thank you for giving us your time. I mean, it's almost like when I hear these trials, I think I have one impression, but anything I say is just a guess. And it's just nice to have somebody on the spot that can give us the insight. It's so important.
Yeah.
Thank you so much for being here.
And mine are kind of guesses too, just a little education behind it. But I mean, we really don't know. I'm just offering up, like, I watched it. I'm kind of reacting to it. I'm like, this is what I think Judge is thinking, but how would I know, right? So yeah, it's just an opinion, but that's what this show's about. So
it is. And you know, one thing I've come to find out is all the people that I associated with, including you, that cover this case, you think that everyone's just voicing your opinion, but you can't cover this case and research it and create videos about it and not get a higher level of understanding or see a lot of things, you know. So I just feel like it's nice because you've seen so many things. You can recall facts off the fly just because you've been covering this case for so long. So, you know, aside from your legal opinion, you've been right here by me covering this, and it's nice to have you here. I just wanted to thank you again.
Thank you.
And I want to thank everybody watching us live. Thank you so much for being here on your Friday night. I know you could have been anywhere, and so we just are glad that you spent this time with us. And anything you see on my live streams, if I haven't said it before, you're always welcome to use any of this footage, any footage from my channel. I please, as long as you're kind, you're always welcome to use any of this off my channel or Gia's channel. And just so you know, Gia's channel, her handle is @GiaPeru. Please go subscribe to her, because as soon as she gets the right amount of subscribers, she can start live streaming on her channel. So we just want to reach that first tier so that she gets building her channel too.
Yeah, because there's really nothing too much over there right now until I can start doing live streaming. But I think I have to have, I don't know how many members. But.
Yeah, and so we make a few videos for Gia's channel off of our live streams, but as soon as Gia has a live stream and she can start making her own content, you're going to start seeing even more original content there. So if you want to support us, please go see.
Yep. Okay. And I was just going to say, I don't know how, said both Daybell cases moved to Boise and the same judge stayed on. So thank you. That's good information. I didn't know if the judge could transfer to the new venue, but that makes sense to me. So yeah, that good to know. Thank you.
Yeah, that's really insightful. Thank you, SH. Thank you so much. And with that, God bless all of you. Have a great weekend. And we're going to be back. Our next live stream is we're going to be doing a deep dive on the Linda Lane footage with Jeff H. So we'll be seeing you guys.
Good. Is he going to do it? Is he good?
I haven't nailed down the date yet, but
okay.
I'll be announcing it on the channel, and then I'll announce it to you first. So thank you guys. God bless. Have a great night.